Checkpoints is presented by pharmaceutical company GM Pharma.
The Georgian legal company MKD Law, based on the request of its client, filed two lawsuits against the National Bank of Georgia and Liberty Bank, which are related to the NBG's possible flawed implementation of the sanctions imposed by the USA. Georgy Aronia talked to Sandro Samadbegishvili, the leading lawyer of the case and partner of MKD Law, about the particulars of the case. Georgy, welcome to the show, and we are all ears.
Hi, Elena. Yes, you are right. Given the importance and scale of this case to the Georgian legal system, BMG decided to talk in detail about it with MKD Law. We sat down with the Sandro Samadbegishvili, partner at MKD Law, who is representing the interests of the client before the court. As Mr. Samadbegishvili explained to BMG, MKD Law represents Metalloinvest, which is a Swiss company sanctioned by the United States of America. The company has placed several million euros in Liberty Bank, the access to which has been denied by the bank. Metalloinvest is a global steel and mining company owned by USM Holdings Limited, which in turn is partially owned by Alisher Usmanov, Uzbek Russian businessman and one of the richest Russian citizens. According to Forbes, Mr. Usmanov's net worth stands at $14.5 billion US. According to Sandro Samadbegishvili, MKD Law does not challenge the application of sanctions as such, but rather the way that they are implemented in the Georgian legal system. The plaintiff argues that the orders of the National Bank of Georgia contradict the Constitution and international treaties of Georgia, as well as the judicial practice of international courts. While MKD Law's main goal is to defend the rights of the plaintiff and unblock its funds, both cases, which have already been admitted by the court, are expected to set precedents in the Georgian judiciary.
First of all, it should be mentioned that it may sound that we challenge the application of the international sanctions, either in general or in Georgia. We do not. We do not challenge the application of sanctions as such. We challenge the way the sanctions are implemented in the Georgian legal system. And when we say that we challenge it, we say that the order of the President of the National Bank of Georgia is not sufficient, first of all, for implementing the sanctions in Georgia. And secondly, its form and substance is not compliant with the Georgian legislation, including the Constitution of Georgia. Of course, our main goal, which we are trying to achieve, is to unblock the funds belonging to the client. The funds were blocked back in April of this year, and the position of the commercial bank where the funds were deposited was that they are implementing the instruction of the National Bank of Georgia, and that this instruction was received by the commercial bank through an email, which is not a proper form of issuing instructions to all the commercial banks. So the law provides that once the rule applies to more than a single commercial bank, it should be publicized, which was not the case, and it appeared that this rule, to which we don't have any access even until now, was into force since 26th of February 2022, 2 days after the war started. We tried to gain access over the document, both from the commercial bank and from the national bank, and we did not succeed. And in parallel, in August of this year, the National Bank issued a normative act. It's a 1.5-page document, which actually has only one operating clause. The clause provides that the commercial banks should follow the sanctions imposed by the US, the UK, and the EU. We do not consider even such kind of normative act to be a regular normative act, because actually it makes reference to the rules imposed by other states and other international organizations, not imposed by Georgian legislative body or it's a foreign act, so it's not originated in Georgia. We argue that this way of implementation of international sanctions into the Georgian legal system is not in compliance with the Constitution of Georgia, which provides for the protection of property rights and which provides that any exclusion to the right of ownership can be made either through the legislative act or through the court order. In this case, we have neither of them. So this is the main point from legal point of view. And in addition to that, the National Bank of Georgia is in breach of not only the Constitution of Georgia, but also international treaties of Georgia, including the European Convention on Human Rights and the judicial practice developed based on this convention, which also provides for the right of protection of ownership. And by the way, not only ownership, but also the right to fair trial and right to legal remedies. In this case, the person affected by sanctions does not have any legal tool to protect itself. So there's no chance to apply to the court and argue that there are no factual grounds for imposing the sanctions against him. So actually, there's nothing a person can do, which again is not in compliance with the Constitution and not in compliance with the international treaty. And there are plenty of foreign and international court judgments which provide that actually this is a restriction of ownership title, and as it is such restriction, so it should have proper legal grounds, which we argue that there are not present in this case. Yeah, basically these are the factual and legal grounds, and of course the purpose of our claims is to unblock the funds, but in the meanwhile we are also trying to improve the legal framework in Georgia for the proper implementation and enforcement of sanctions in Georgia, so that it cannot be challenged in future for the same grounds.
The court proceedings have not started yet, but BMG will monitor the process and inform our viewers about the case proceedings in the near future.
Of course. Thank you, Georgy, for working for the checkpoints this week.
The Checkpoints is presented by pharmaceutical company GM Pharma.